Afternoon, everyone. My name is Komotso Mokwena. I'm a lecturer at the University of Johannesburg. Thank you so much for joining us today for our conversation with Justice Edwin Cameron. We are going to enjoy listening to his reflections of a retired judge, particularly in this time, in this day and age. So I really hope you all enjoy the conversation. I just want to say thank you very much to the Faculty of Law. Our Executive Dean, Professor Litlokwa Mpedi, is joining us today as well. We thank you so much for the opportunity to engage with Justice Cameron in this way, in this time. It's unprecedented. We haven't done something like this before. So I think we're all really excited. Today, there is opportunity for guests to ask questions. I'm going to be regularly checking the Q&A and chat box to make sure that I engage with your questions. As many of your questions as possible. Bear in mind, we only have an hour. So I'm going to try and answer as many questions as we, or get to as many questions as we can. I think we've got a few questions from the faculty as well. So we'll slip those in as well as we go. But just to introduce Justice Cameron, thank you so much for joining us today. I think everybody who's part of this conversation knows who you are, so I won't lament on your bio. I know you don't like that. so I think it's very important just to note that you retired from the Constitutional Court bench in 2019. And I think it'll be very interesting to listen to your views on the state of things as they are now, your views on transformative constitutionalism, and your perspective of the direction that our country is taking. Thank you so much for joining us.
What a pleasure, Komotso, and I'm thrilled to be here with you this afternoon. I'm very pleased and honored to be hosted by Dean Mpedi and by the UJ Law School and by UJ itself. And I'm thrilled at the number of people who are joining us. I heard a lot of interest from people who contacted me about this event over the past 10 days or so. And I'm really looking forward to an exciting interchange with you.
Great. So, Judge, I'm just going to kick off with a couple of sort of questions more about your work, your previous work on the bench, and really if you feel that there is a connection to particularly what your ongoing judicial philosophy was during that time in connection with the project of transformative constitutionalism in the country.
Yes, I do think there was, Komotso, the background to our transformative constitutional project, of course, is the Constitution itself, which expressly stipulates that it is a transformative document. There are debates in other societies about whether judges are activists. I think that's a miscast debate because judges who believe in human dignity and in greater equality were wrongly styled activists when the activists now are very often judges on the ideological far right, especially in America, who don't believe in greater equality and greater justice for all people and greater access to voting rights. In South Africa, that debate was even more miscast simply because our constitution placed a very large responsibility on the judiciary within its role. And may I say, Komotso, that responsibility wasn't lightly given. We had an interim constitution that took effect on the 27th of April 1994. And then the Constitutional Assembly, which was our first democratic elected parliament, became a constituent assembly chaired over by our current president, President Cyril Ramaphosa. And that parliament had the tough job of deciding whether to include social and economic rights in the Constitution and whether to give the judiciary the power to enforce them. And after a big debate with some very distinguished lawyers saying, no, don't, and others saying, yes, do, those powers were given. And my overall assessment of the last 26 years is that we haven't done great. We haven't done all that we could have done. We haven't done all that we should have done, but that the project of transformative constitutionalism is genuinely underway. And the judiciary has held the executive to account in the famous judgment of Chief Justice Mogoeng on the 31st of March 2016, during the Nkandla fiasco, we held Parliament to account as well. But that was our job. It was unavoidable. The judiciary does not go out looking for scraps. It does not go out looking to swagger around with its powers. We prefer to keep low profile and to do the job of judging. But we've done that. We've got a long way to go, Kumutso, with injustices, with dispossession, with inequalities, with gender subordination and violence, with racism, with homophobia. But we have made a start. And looking at other comparable societies like ours, like Brazil, Turkey, China, India, I think that we can feel some small vestige, at least, not self-satisfaction, not complacency, but some small vestige of pride in what our society has achieved under the Constitution and what the judiciary's role in that has been.
You mentioned that, and you've sort of said, we aren't where we want to be. In your opinion, if you are willing to take a view, what is pulling us back? What is holding us back from achieving some of the goals that we are striving to achieve in terms of transforming our society? Is that something that is just a matter of time? Because my initial view is that it took a long time to build an ugly thing, to create all these problems. And it might take a very, very long time to dismantle some of these existing systems and issues.
I think it is structural impediments, Kumutso, but I also think we have to name the big ugly beast in the room as well, which is governmental failures, corruption, mal-assignment of cadres and deployees, people. Minister Dr. Nkosazana Dlamini-Zuma the other day said in Parliament, I think quite rightly, that the mere fact that someone is deployed doesn't mean that they're incompetent, but that also doesn't mean that we haven't had many malign and incompetent deployments. So I think the question of governmental failure looms very large in our constitutional project. And that is part of what the judiciary has held Parliament and the executive to account for. But of course, there is the issue that you've raised, which is our history of deeply systematized structural inequality and white privilege and white racism, from which I benefited as a young person growing up poor in the 1950s and the 1960s, getting into an excellent government-funded school, getting into an excellent government-funded university, both of them all whites, Stellenbosch, and before that, Pretoria Boys High. So there's that also to deal with, but I think that we could have made more progress. But Kumutso, let me mention the other big ugly factor in the room, and this is one on which the judiciary genuinely is disinterested. It's the question of economic growth. I watched the debates in the pages of our daily journals and in the newspapers. I watched the debates between various groups of economists. Judges don't have views as to whether there should be more state control or less state control, but that debate is an important one for our democracy as well, because we were in a state of catastrophic low growth and even recession. The first quarter of this year, even before COVID struck us, the present national disaster, we were trapped in a recession. And of course, COVID has set us back even more catastrophically. So there's that as well. And that's all in answer to your question about what has held us back.
And maybe on COVID, if we can spend a little bit of worth spending a little bit of time really considering, you've obviously engaged with the regulations and probably a lot of the judgments that have come out in relation to the regulations. And I wanted to get a sense as to whether or not you had any sort of, judicial nigglings, troubles, things that are bothering you about whether the enactment of the regulations or their implementation and what our courts have said so far.
Definitely, Kumut. So you want to provoke me and you want our hour together
Always.
to be interesting.
Always.
Lovely, Komotsobi. I'm going to be provoked. Let me say this. I'm speaking as someone who was a young man and a human rights lawyer when AIDS beset us, and I became infected with HIV myself 2 years into practicing as an anti-apartheid lawyer in the 1980s. I fell ill with AIDS after I was a judge, and I had my life given back to me with antiretroviral therapy nearly 23 years ago. And I think we've reenacted many of the mistakes. I'm not going to talk about particular regulations about alcohol or smoking or whether Minister Patel was right to allow certain kinds of warm clothes or not warm, other kinds. I want to talk about the overall approach to a catastrophic health disaster. And what the AIDS epidemic taught us were a few important things. The first thing is that those who are most vulnerable socially and structurally are the worst affected. And we've seen that again. People like myself, I'm in a warm flat and I'm protected, but many tens of millions of our people are. The second are not. The second thing that AIDS taught us is that strong arm tactics are wrong. And I don't say this to fight with General Cele or with anyone else. I'm speaking as a matter of 4 decades of history. The strong arm tactics of bursting into homes, of arresting people large scale, that's the wrong approach to a public health disaster. You have to respect people's rights. You've got to lead people. We've got a respected and competent president. We didn't have a respected and competent president for all of our history. I'm not going to name names. I'm talking long historical view. But President Ramaphosa is a competent and respected man. I knew him in the 1980s. There's no question he's not in this for his own gain. And I think that we could have used more of his leadership, like I believe and said at the time that we could have used more of President Nelson Mandela's leadership in AIDS. So those are the facts that we've learned, that respecting people's rights and conserving public health and containing contagion are not opposite goals. They are goals that mesh together. So from that overall perspective, yes, I think that we made very big mistakes. And I think that particular regulations that we don't need to go into are examples of that. But also the security forces crackdown. It was a terrible mistake. Let me give you another example, Komotso, and then I'm going to keep quiet because judges talk a lot, because I want to hear your next question. But let me give you another example. I went to the Johannesburg Correctional Center in May, 2 months ago, for a visit to check what was happening with the COVID implementation of protective equipment, of sanitization, of contagion control. And we were briefed by the Department of Correctional Services officials. They said that since the lockdown regulations, the awaiting trial prisoner overload had increased by 10%. Now, you don't want to go to the awaiting trial section, I think it's medium B, at Johannesburg prison, which is popularly known as Sun City. It is really miserable. 70 people crammed into cells built for 22 people. And the idea of arresting people en masse for lockdown regulations was a terrible mistake from infection control, from human dignity perspective, and from correctional carceral management perspective. That's my example. I'm going to look forward to your next question.
I would really like to get your perspective, because I think that the interesting thing about the regulations and COVID-19 as a sort of unique South African situation, or fairly unique situation, even for the world, is that it has inspired a lot of almost legal activism from ordinary citizens. People are engaging with the regulations, people are engaging with the law, what is constitutional, what is not constitutional. And I would like to get your view on the ability or the role of the judiciary to inspire active citizenry. Is the judiciary in a position to inspire people to change their circumstances or engage with the state themselves as opposed to going to court? Or are we seen as an emerging litigious society? Are we becoming more litigious as we go along?
Well, being a litigious society is a part of our history. The Western conception of law landed with Van Riebeeck in 1652. It was overlain in 1795 and then in 1803 and 1806 by the British occupation, with disregard for indigenous existing systems of law, which were intricate and well established. But we recognized those in our 1994 Constitution for the first time. Common law and indigenous law were both preserved and recognized, provided they were consistent with the Bill of Rights. So we inherited from apartheid that litigiousness, because apartheid was enforced minutely, rigorously, humiliatingly, most injuriously through a complex web of legal regulations. That's why the most famous law firm in South Africa's legal history was established, Mandela and Tambo. After the Defiance campaign, this young, hot-headed lawyer, Mandela, took to law, and he represented many people, and they had great legal successes. And Mandela and Tambo gave rise to a generation of legal activists like George Bezos, Arthur Chasselson, Sidney Kentridge, Godfrey Pitchie. And then I was part of a second and third generation, a small part, at the Center for Applied Legal Studies at Wits University. And that tradition of tackling injustice through the law comes from Mandela, because Mandela said, this isn't the law, this is apartheid law, and it's wicked and unjust, and we must fight it. This legal system should be just, and it should do better. So with that call to legal activism, we entered our democratic era. And the legal institutions, the Legal Resources Center, Lawyers for Human Rights, Center for Applied Legal Studies, various, the AIDS Law Project, which is now Section 27, SERI, and others that were founded after the Constitution took effect. They are part of our legal tradition, where we say to our citizens, you're not dumb. You don't have to accept injustice. Fight against it through demonstrations, through expressing yourselves, all of these rights which are now preserved in the Constitution, but you also have the right to go to court. So I see it from that perspective. I don't think that we are too litigious. I think that, for example, let me take recent examples that you raised of COVID challenges. One judge, Judge Davis, was argued to have gone excessively in striking down regulations. Two other judges, Judge Roshni Ali and the second judge in Cape Town, were argued to be too deferent. Those cases will go on appeal, and the Supreme Court of Appeal and eventually the Constitutional Court will decide who was over-eager or under-eager on what side. But I reassert, Komutso, that we come from a society where people are rights alert. I think that's what distinguishes us from many of our brothers and sisters elsewhere in this continent and elsewhere in oppressive societies, that our people know that from Sharpeville, from the Durban strikes of 1973-74, from the Soweto uprising, from the foundation of COSATU, with Cyril Ramaphosa there, with other leaders in the 1980s, with the UDF, we took control of our history. And part of that history is legal activism. So I don't apologize that equal education, which was founded by a distinguished lawyer called Deron Isaacs, I don't apologize that they took government to court. And a High Court judge in Pretoria was asked to look at the fact that government abandoned the child nutrition scheme when the lockdown occurred. Now, that's a terrible thing, and you can read Judge Potterall's judgment. I don't know if it's going to be appealed, but it's a most heartrending issue that millions of kids whose only meal came from the child nutrition scheme at schools were suddenly left out in the cold. And the reason government gave, which is that the schools had to be closed, wasn't good enough. And I'm very proud that one of my judicial colleagues intervened there. I don't know if that judgment's going to stand, and I won't blame the judges who might reverse it on appeal, but I'm proud that that issue is being played out in the courts rightly where it should be.
And perhaps let me provoke you a little bit more and ask
Yes, please.
and ask the question a little bit in reverse. So,
Yes.
for obvious reasons, and I'm going to, I'm going to leave out and not sort of name names, but I would really like to get your view in relation to commentary of judges. What are judges allowed to say off the bench? Maybe we'll talk a little bit about the role of retired judges specifically, but a sitting judge. If I would really enjoy it if you took a view on the sorts of things, or whether or not they should be able to speak at all, and the sorts of things they should be able to speak about in public. And you would have so much experience because you were a very active judge whilst on the bench. So that would be an interesting question for me to hear the answer to.
It certainly would, and you are provoking me. Let me say a few things. You didn't name names, but I'm going to name names. Chief Justice Mogoeng. He was appointed Chief Justice in 2011, and without him and Deputy Chief Justice Dikgang Moseneke, I'm not sure that we would still have had a constitutional democracy. It's that same willful, bloody-minded, strong-headed commitment to principle on the part of Chief Justice Mogoeng and Deputy Chief Justice Moseneke that saw us through some of our worst times and established the judiciary. So I'm saying something pertinent to your question, which is that I think Chief Justice Mogoeng is a strong-minded person who will always express his views. Having said that, I want to refer to myself, which is that as someone who became infected with HIV, fell seriously ill with AIDS at a time when hundreds of thousands of our country people, men and women, most of them poor Black people in South Africa, were dying of AIDS. I got access to antiretrovirals, which saved my life because I could afford them as a judge. And at that very time, President Thabo Mbeki took office in May 1999. In November 1999, he started signaling that he did not accept medical science or conventional etiology of AIDS. It was a catastrophe for us, a horrible catastrophe. What did I do? Did I keep quiet? No, I spoke out. Now, when I came up for a constitutional court post at the end of 2008, a JSC member, Maruma Muirani, tackled me about this, and I think rightly. He said, you criticized a sitting president. He wasn't being hostile, I don't think. And he said, how could you as a sitting judge? And my reason was that this was an epidemic of silence, an epidemic of shame, an epidemic of stigma. I had had my life given back to me. I had a voice. I'd spoken out as a proudly gay man from the 1980s. I was appointed by President Mandela as a proudly gay man. And I didn't have to speak out on LGBTI affairs because there are many voices. There were Phumi Mthethwa, Zaki Ahmed, many other voices on LGBTI. But on AIDS treatment, I had to speak out. And I spoke out against the president. Now, the question I'm not going to answer, and you can answer it, is whether it was necessary in the case of the Israel-Palestine situation. Who was the weaker party? Did the weaker party get protected? Was the stronger party intervened? I'm not going to express a view on that, Kamutsu, even if you provoke me further.
Well, nobody can say I didn't try. I'm just going to take a look. We've got a question from one of our guests who would like to ask your opinion on judicial independence in Zimbabwe. I know we've gone a little bit off track, but I'll bring us back. But I just want us to engage the audience a little bit more. A number of prominent African jurists, including Justice Prof. Lillian Tibatema of the Supreme Court of Uganda, has spoken out regarding a directive of Chief Justice Malaba, wherein he directed all judgments must be approved, later changed to C by judge presidents before being handed down.
May I say that I think the record of judicial assertiveness in Zimbabwe is very checkered. It's very uneven. There were some great judicial tragedies. It was alleged at a crucial time in the 2000s, when there was widespread evidence corroborated by President Mbeki's mandatories, plenipotentiaries, Deputy Chief Justice Dikgang Moseneke and Justice Sisi Kampepe, two of the most distinguished judges of the constitutional era. They were sent to Zimbabwe in 2002, and they said this election was not free and fair. At that very time, the Zimbabwe judiciary was inert, and it was alleged that the Chief Justice at that time had received farms in the unlawful appropriation and transfer of farms. So I can say that. And the second thing I'll say is that the notion that within a judicial hierarchy, other than through appeal, your judgment should be scrutinized and vetted and, worse still, approved by a senior judge is calamitously incompatible with any idea of a functioning independent judiciary.
And maybe staying with the role of judges, but moving a little bit towards the role of retired judges. A number of our greats are moving into retirement after you. So I would really like to get your sense of what you believe the role of a retired judge is, particularly in our context.
Kubutso, my view is the same as I told Mr. Murumu Muirani at my interview 12 years ago, which is that judges should shut up. And I think that applies after your retirement as well. I speak out about prisons. I speak out about LGBTI oppression, torture, murder, imprisonment across the rest of Africa, because as an African queer man, I cannot be quiet. I speak out about AIDS stigma and about AIDS treatment, because this is still a terribly silenced epidemic, an epidemic of muteness, when we have 7.5 million people living with AIDS and HIV. So I speak out about those issues. I've got views on schools, I've got views on land invasions, I've got views on the DA and the EFF and the ANC, but I must shut up. There are other people who can express those views. And if there's a scholarly lecture on the value of land invasions, I'll go and read up everything and I'll express scholarly views, but I won't give a media interview and speak out about those things, because there are lots of people who can do that.
Taking us a little bit back towards the discussion around transformative constitutionalism, we've got a question from Heinz, and Heinz has asked, what is the relationship between transformative constitutionalism and the problem of governmental implementation of judicial decisions? You've touched on it, but maybe you want to elaborate a little bit.
Yes, I think Hein is asking an important question, Komotso, because it is, on the whole, we have had, over the last 26 years, a fairly good implementation rate by government, even in contentious areas in the Eastern Cape, with the grants program, where the Supreme Court of Appeal in the 2000s ordered the Eastern Cape government, which had illegally cancelled people's grants in order to root out fraudulent grant recipients. And even with AIDS, when the Constitutional Court in 2002 ordered President Mbeki to start making antiretrovirals available, there was a lot of foot dragging, but eventually, within 2.5 years, we had a national HIV antiretroviral treatment program, which is now the world's largest publicly provided antiretroviral treatment program, with more than 4 million people whose lives, like mine, are being saved by that program, publicly provided and cost-free. So there have been, I think there are difficulties. For example, I think that there have been difficulties at appellate level that I've been aware of since the COVID lockdown. The Constitutional Court for a while didn't hold hearings. The SCA has been holding hearings online, so that there's been adjustments. But I do believe that during the lockdown period, there have also been difficulties with enforcement of judgments. But if Hein is implying that in order to have effective transformative constitutionalism, you've got to have effective judicial remedies, then I think that Hein is right. And I can't say that that has been 100% the case in our constitutional era.
Okay, so
there's a question from a first-year law student that I'd love to answer.
Which one? Which one? It's one of my students. Which one?
Yeah, it's a wonderful question. I think it's from Sia or from someone else.
Let me.
What advice can you give to a first-year law student who has an enormous desire of becoming a judge like you one day? I believe it's a judge like you, not a judge like you. So become a judge as I did. That's how I interpret the question. And it's a good question, Kumutso, and I'd like to address the law students who are our participants, because the law can be used in different ways. The law can be used as it is being used in the United States at the moment. Here I am being controversial, but it's something that falls within my field of expertise, to block out voter registration, to block out equal apportionment of voter districts, because people don't want a mass registration. The law can be used to make it difficult for Black people, for example, in the United States to register. I think all of these things that I'm speaking about are well documented. But there is another use for the law, and that is the use for the law that President Mandela saw when he was an embattled post-defiance campaign lawyer with a suspended sentence hanging over his head. And that is to secure justice. That is to secure protection for the weak. That is to scrutinize power. And I want to encourage, is it Nicho or Nito, who's the first-year law student? I want to encourage them to believe that in South Africa, it is particularly important for us to nurture and cherish a vision of the law as an instrument of greater justice, an instrument of greater equality, an instrument of lesser domination, of lesser stigma, of lesser discrimination, an instrument of greater human dignity. What stands at the heart of our Constitution and is one of its most important founding values is the right to human dignity. And why it is there is because of our history of the degradation, the systematic degradation of people's humanity under apartheid. So I think that every lawyer, I'm not saying don't become a commercial lawyer. I'm not saying don't seek to make yourself and your family comfortable. But I'm saying that if we as lawyers don't fight for the poor and the marginalized and the dispossessed and those left behind in our society, then our legal system is not doing its job and our constitution is not working.
From Professor Fombad, who has asked, what would you say are the key elements of transformative constitutionalism, and have these evolved over time?
Well, the transformative constitutionalism, I think that for me, I'll single out obviously the project of racial transformation and racial justice. And then secondly, equality. And equality is no longer a racial question. Equality is for me, very much a class question, where we have formed a new middle class, a new elite, a largely Black elite. And I think transformative constitutionalism requires attention to both those. The question of substantive equality. I think we've become in many ways a more unequal society. I haven't quite got the economic statistics there, but in many ways we've made progress where some forms of poverty have been diminished, but there are also a sector of people, the least resourced people, which has become greater. So that we have to tackle. And then, of course, as well, the question of racial justice. And can I just go back to the controversial issue of land justice, and land invasions? We can't avoid controversy, and we should embrace it, because that's at the heart of transformation. On the day that I stepped down from the Constitutional Court last year, we gave a very important judgment in the Mlase case, which concerned a man who was living on a farm. And when you talk about a person living on a farm, for most of South Africa and for most of its history, you've talked about the farm belonging to a white person, and you're talking about the man or his spouse or the woman being Black. And in the Mandela era, a wonderful statute was enacted called the Labor Tenants Act. And that act said that if you are living on a farm and you are tilling a piece of land around your homestead and you have got some livestock around your homestead, two things happen. The first is that immediately upon enactment of this, you get security of tenure. You can't be chased off the farm, as for 350 years you could be chased off. But the second thing that statute did was to say you can actually get the property title. You can get that piece of land. And if the landowner says, no, I dispute whether it's 50 acres or 50 hectares or 5 acres or hectares, I dispute that. It's got to go to the labor court, to the land claims court. But the pivot in the middle of that was the land department, and the land department failed miserably. There were tens of thousands of applications by labor tenants to get their property transferred to them, and the Department of Land Affairs failed them mercilessly and miserably. And the judgment that we gave said, we're going to send someone in. We upheld the judgment in the Land Claims Court, which was overturned by the Supreme Court of Appeal. We reinstated the judgment of the Land Claims Court and said, send in a competent administrator to get these claims sorted out so that people can get their property. So again, the importance of legal process, again, the fact that governmental failure and inaction and corruption did not succeed in giving transformation when it could be achieved and was available.
And Judge, you touched on some of the social issues and the class issues that affect everyday lives of South Africans. And I wanted, somebody asked a question relating to the appointment of judges to the bench and whether or not the processes are fair in relation to allowing political parties to engage with that process. And I'd like to hear your view on the importance or the significance, if any, of a judge's sort of socio-political consciousness when one is considering appointing them to the bench. Is that something that's very important, or is it important that judges sort of apply the law to the letter, and that's what we're looking for in an ideal judge?
So when you apply for the bench and when you are appointed to the bench, you bring your whole history with you. That doesn't mean that you come with an agenda. And I'm really proud to say that in my 11 years on the Constitutional Court, I remember I had a law clerk once who, at a time when we were deeply divided out, those divisions broke up a bit. But for the first few years on the court, there appeared to be two camps. And he said that there was a big application from the Western Cape, which is a DA-run province, and it concerned the Khayelitsha Commission, which the DA Premier had appointed. And the police minister disagreed, and it landed up in our court. And the law clerk arrived in their first month, just before we were due to hear the case, and he said, how will the division in court play out, because this is a DA applicant? And I said, honestly, and this is not because I'm naive, that has never occurred to me. And what happened in the next 10 weeks, Kumutso, is that we looked at the provision of the Constitution, roundabout section 205, that says that a premier of a province may appoint a commission into policing. No one even raised, let alone gave consideration to the fact that this was a DA premier and an ANC minister. That might not be the way the minister wanted it, but I can promise everyone that the business of judging has no place for partisan or party political agendas. Beyond that, you bring in your own, you use the word socio-political, and I think it's a beautiful word because it subordinates the political to the socio. And I think that your socio-political views about human dignity, about gender equality are important and should be scrutinized, but not in a party political context.
And maybe on that, maybe it's an opportune time to talk a little bit about your activism in relation to LGBTI rights. And very recently we've gotten the Civil Unions Amendment Bill that allows, that now stops marriage officers from being able to not marry different couples because of, what did they call it, religious consciousness or something along those lines. Can you tell me what your view is in relation to whether or not that will be effective to limit the amount of discrimination that LGBTI couples experience?
Well, I love to talk about history, as you've gathered, because I think we have to see our history. I think it's extraordinary that we got the Civil Union Act in 2006. It was a remarkable compromise, I think brokered by Mr. Johnny DeLonge, whom I don't always speak fondly of, because he also was responsible for statutes that I'm criticizing a lot in my role as inspecting judge of prisons, the Minimum Sentences Act. And I hope we can get back to that, Komutso, because minimum sentences have been a catastrophic failure, counterproductive, wrong-headed. They have not secured our people from crime. They've crammed our prisons up. But to his credit, the chair of the Parliamentary Portfolio Committee on Justice did this brilliant compromise where he said, we'll not amend the Marriage Act of 1961 to say that same-sex couples can marry under it, but we'll create a new statute under which both same-sex couples and opposite-sex couples can marry. And when they do, their marriages will take effect as marriages under the 1961 Marriage Act. Now, that was a very, very clever lawyer's compromise. But the one provision, Komutso, that made an exception was that as a state-employed, state-appointed marriage officer, you could refuse on grounds of conscience to marry same-sex couples. And I think that was wrong. And let me tell you why it was wrong. I don't say it only as a proudly gay man. I say it that because when you are in the public sphere, either as a license holder or a shop owner or premises in a mall or offering services or goods to the public or practicing your public service as a public service officer, you should not be able to discriminate against anyone, whether it's a black person or a Tonga-speaking or a Venda-speaking person or a gay or lesbian person. So I think it was wrong in principle, and I congratulate Parliament and I congratulate the political parties. I see that some of the opposition EFF MPs got an ear scrubbing from their leadership for not supporting it. And I'm very proud of that. So I'm proud of the parliamentary process, and I'm proud that that was removed. The bigger question you're asking is about the fact that there is still homophobia, particularly for lesbians in townships, black women who are same-sex oriented. They are at risk. There again, we have risk and discrimination, which is vectored across class lines, because in my area, a black lesbian, a gay black man, a white queer man are relatively safe. But I think we've still got a long way to go, as we have got to go with gender discrimination, gender subordination, and with racism. I think in all those things, we've still got a lot of work to do.
I was actually going to ask you as a follow-up, you know, I often teach my students, you know, we refer to the Constitution as an aspirational document. It's where we want to be. And how, if you really had to take a view on what is happening on the ground in terms of how people are engaging, from whether it's in relation to racism or homophobia or sexism or any of these issues, you know, how far are we? Where are we going? And is there a silver bullet to changing really the minds of us, of South African society, over and above legislation and judgments?
The way we change the mind of constitutional skeptics is by showing that the Constitution can advance justice, by making the distributional shifts, the property relational shifts that will empower poor people and give them a share of what those of us who are empowered already have. So I think that is the way to do it. And of course, to get back to the first-year law students' question, which I was so eager to answer, I think that to the role of lawyers, every lawyer in South Africa, every law student in South Africa is an agent of constitutionalism. I sometimes get questions, about the Mandela question. You haven't asked me about the Mandela settlement. And I always welcome that question as well, because I think Mandela did a good deal. And I want to tell you why he did a good deal. It's not only because we might have faced civil war, not only from the AWB, the far right, white right-wingers, not only from General Constant Viljoen. We also might have faced civil war from Mr. Buthelezzi's Inkatha MPs, who only came into the constitutional project a month before voting day. So the Mandela Constitution was a consummate compromise at times of enormous precariousness when everything could have gone wrong. Right at the time when just 3,500 kilometers to our north in Rwanda, we had a massive genocide. So when people say to me, was the Constitution a good thing? I say we've got alternatives. We've got President Paul Kagame, who was re-elected with 98% of the vote. Do you know that, Komotso? Wouldn't you like 98% of the vote? I would like to see those ballot papers because I'm frankly skeptical. And he has got very, very, very authoritarian powers. I don't want to go that route. A constitution is frustrating. Legal process is frustrating. But we have got the right of free speech. We've got the right to demonstrate and to protest. We've got the right to organize, to associate freely. We've got a free media. We've got a good legal profession. We've got all those things. We just have to do much better with them.
On that, if I can maybe ask, I mean, you've stepped over our borders a little bit, and really, I want to get a sense of what you think our role is as South Africa on the rest of the continent, seen as a leader. What would you think our role is, generally speaking, as a nation?
Humility. Humility, Komotso. So let me tell you why. We thought we were so big stuff. With the AIDS epidemic, we were going to do better than Uganda. We did not do better than Uganda. We did worse with many things. So I think even with cross-border migrants, I think we have a lot to hang our head in shame about. These were frontline countries and other countries that gave shelter to people who had to leave because of apartheid. And now we have a complex problem, and it is a complex problem, of criminality mixed with xenophobia. And I think you've got to mention the X word. You can't leave it out. So I think a lot of humility, but also I think that the constitutional project, next month, there's an internationally LGBT organized international LGBT pride event called Pride Afrique. It's organized by people in the African diaspora across the whole world. It involves LGBTI activists from every corner of Africa. And I think that our constitutional record on LGBTI equality is something that, with humble pride, we can speak about justly. And where we do have things to speak about with pride, for example, a free media, for example, free opposition parties that are free to express themselves, for example, the freedom of association, we should speak out about that with humility, but also with a measure of pride.
Judge, we've got a very interesting question that's quite topical at the moment, although, it should always be topical. But the question is really, where do you see government's role or the role of the judiciary in relation to gender-based violence? I mean, you spoke earlier about the prisons and about minimum sentences, and people often believe that the silver bullet is very high sentencing. And maybe you can give us your thoughts on that.
Komotso, I'm involved with an organization founded by Juanita Meisfeld, who's a law professor at Kells, where I was in the 1980s and early 1990s. And it's based in Diepsloot, and it deals with gender-based violence. And it helps people assert their rights, get counseling, and take the perpetrators to court. I have absolutely no doubt that legal process is an essential part of teaching men that women are not their objects to be violated in any way. But my strong view, and it's a view that I've expressed repeatedly and will continue to express, is that to take a small handful of rapists or gender violent men and put them in jail, lock them up and throw away the key, as people like to say, does not solve the underlying problem. I believe that criminal arraignment and criminal imprisonment has a role, but the length of sentence has, I can say this with complete assurance, the length of sentence has no impact it's the certainty of prosecution, the certainty of arraignment, the certainty of sentencing, not how long. So we've got to jack up our entire criminal justice system. I know when people ask me what we can do about this or about child rape, they're asking for bread, and I'm giving them the stone of process. And the stone of process is that we've got to get our police responsive, we've got to get the supportive units in the police responsive, we've got to set an example within the police and government to our communities. We've got to set the example at community level about how women are to be respected and honored and valued and nurtured and not trampled upon. So it's a long process in which the law has a role, but in which long sentences and throwing away keys has no constructive role.
Thank you. That was helpful even to me, because I often have sleepless nights thinking about this issue. I think I will, in our last few minutes, I will try and keep it a little bit lighter. But I will ask, one of the questions that has been posed is, which judgment from your time at the Constitutional Court is the judgment that you believe you're the most proud of, or had the most impact?
Well, it's a judgment of my sister, Justice Sisi Kampepe. And it concerned a mine worker from the Eastern Cape called Mr. Mankai. And he worked hard in the mines and made a bit of money for his family. I don't know whether he helped his children and grandchildren to get to university, but in his 50s, his lungs collapsed. And he was sent home to the Eastern Cape with 16,000 Rand compensation. And he brought a case, and the mine said there is a provision in the relevant statute that says you can't claim more compensation. And he attacked that. And Justice Kampepe reinterpreted that provision in a way that I was enormously proud of in her judgment in Mankai. And she said, you are entitled to compensation. And the result was an extraordinary process which resulted in the mining companies creating a 6 billion Rand fund for people like Mr. Mankai. Mr. Mankai, unfortunately, died very shortly after Justice Kampepe handed down her judgment. Mr. Mulasi, by the way, the labor tenant who came to us from KwaZulu-Natal, he died even before he got to our court. So I'm very proud of Mankai, and I'm very proud of the fact that there will be a significant shift of resources to mine workers, and let's say the word black mine workers, who created this country's wealth and infrastructure. And they did so at a terrible cost to them and their families. And then I'd like to mention a judgment that I co-wrote with Justice Dikgang Moseneke, Deputy Chief Justice, which is the Glenister judgment. The Glenister judgment struck down. The first thing that President Zuma did when he took power was to abolish the Scorpions, who had been a corruption-busting unit. And in their place, Parliament enacted a little pussycat, which at that stage was called the Hawks. And we said, no, this pussycat's got to have claws, this pussycat's got to be able to roar. We said we realized and domesticated South Africa's international convention obligations, which our democratic parliament had signed. Those conventions said, you've got to have a corruption-busting unit that has got real teeth and that is really independent. We sent the legislation back twice, not once, but twice. The second judgment by Chief Justice Mogoeng, saying, endorsing and applying the majority judgment in Glenister. So those are the two judgments that I'd mentioned, and thank you for the opportunity.
Judge, last question. One more question before we go. We've got 4 minutes. This is a difficult time for South Africans. There is a lot of despair, if I may be honest, just based on everything that's happening. And I want you please to show us or tell us where you think the hope lies, where you think the promise lies, wherever that may be. Maybe that can be your parting words to us.
Thank you for the opportunity, Kumutso. I want to go to history again, and I want to draw lessons from it. In the 1930s, there was a global catastrophic recession, and there was a drought as well. And South Africa was devastated. That was also about 12 to 14 years after the Spanish flu of 1918, which killed many, many people in our country, underdocumented and understood. And I want to draw the following lessons. What happened is that there was large-scale governmental intervention in favor of the poor. But which poor? The poor whites. But there was one more thing, Kumutso, and this is also important for us. The poor whites and the elite Afrikaners founded a lot of businesses and a lot of organizations to help themselves. So there was an incontestable government intervention, which eventually favored poor whites like me 30 years later in the 1960s, when I got to go to a super elite government public school. But there was also a commitment to help themselves. And the Afrikaner, on the back of governmental support and transfer of resources, also took the initiative with pride and condemned corruption. So we have got a complex history of racial stigma and racial pride, and we have got to grapple with that. I've done a TED talk on the way that shame, we internalize it. I've spoken as a gay man about how we internalize shame. I've spoken as someone living with HIV about how internalized stigma makes us silent about HIV. And I also spoke about how we internalize racial shame and how Steve Biko spoke about. He said black people must cast aside what he called, quote, inferiority complex. It's not my word as a white man, it's Steve Biko's word. So the Afrikaner cast aside his inferiority complex and asserted pride. And I think we have to do both. It is a difficult time, you're right, Kumutso, but I believe that with proper governmental, properly regulated and accountable and transparent governmental interventions, plus popular effort on the part of all of us, white and black, poorer and more resourced, we will get past this. Thank you.
Thank you so much, Judge. This has been an absolute joy. I really, really enjoyed this conversation. And I thank you so much, everyone who joined us today. Thank you to the Faculty of Law. Thank you to our University of Johannesburg Library for organizing this event. Thank you to Professor Mpedi, our Executive Dean. Thank you, colleagues, all of our colleagues who joined. Thank you so much again, Justice Cameron. I cannot thank you for your time enough.
And may I thank you, Kumutso, very much for, I hope this doesn't sound gender directed because it's not, for being an extremely charming interlocutor and for an interesting hour, and also to thank the faculty. And I also want to thank everyone who stayed online. It was an exciting hour, and I'm very sorry we haven't got to all the questions.
Thank you, everyone.
The University of Johannesburg, the future reimagined.